So there might be 5 elements. I can say, no, I'm not worried about these 2 elements. But if these 3 are not there, the crime is not there. That's really what I'm doing. Now, so let's go to...
We're moving to a
sentence.
Subject of the sentence.
Yes. Thank you, my Lord, and I hope your Lordship will give us some leeway because of the interaction which we welcome. My Lord, I was saying before this interaction that the issue of the sentence, if anything, this court can decide this matter on that issue alone. Assuming the court even reaches the merits, assuming the court says the IEC has some power to administer Section 47. Here is the issue, madam. Let's go to what the Constitution actually says. It says, let's put it this way. The Constitution makes it clear in Section 47 that what it is interested in is what we call the ultimate sentence. Again, it's a purposive interpretation. The reason why the Constitution could have just said, if you are convicted and sentenced to a crime of for more than 12 years, full stop, right? But it didn't. It went on to qualify, and words, even in a statute, must be assumed to have meaning and a purpose, let alone in a constitution. It went on to say, but one may only be regarded or deemed, as we say in law, of having been sentenced. No one may be regarded as being sentenced until an appeal against the conviction or sentence has been determined. Let's just pause there. So, on a purposive interpretation, my Lord, it's clear why they put that proviso. Because they say we're interested in the ultimate sentence, not the original sentence. And the ultimate sentence could have been a result of an appeal. And that word, again, to go back to the wide and strict, must be interpreted widely, my Lord, to mean anything that might reduce that sentence must have happened or not happened. So let me give you an example, my Lord. If the person had not appealed but applied for a rescission, and then it's set aside,
Sorry. We are within the context of the criminal law. So rescission now, where does rescission come in?
Well, my Lord...
unless, of course, if you want to say review, then I would understand.
Okay, let's say let's make it easier.
Because that's the only way you can achieve the setting aside of the court order on conviction and sentence, either by way of a review or by way of an appeal. So let's stick to...
There's the Rule 42. Actually, this case we're talking about actually went on Rule 42, but that's fine. Let's leave that. Yes. And 2 judges of the Constitutional Court declared that it should be set aside as a rescission. But let's leave that. Let's use a review.
Okay.
If the sentence, for argument's sake, was set aside by way of review, yes, you can't then say, no, but the section says appeal. Because that's not a purposive interpretation. The purpose is to find out what ultimately happened. Yeah. No, again, it goes to normally it happens by way of appeal, but it can happen by way of review, it can happen by any other method. But the point I'm making, which I really want this court to remain with, is that Section 57 concerns itself with the ultimate sentence. Right. Now, if we accept that, then we make 2 criticisms. One is that this one was not even appealable, so that's part of Section 57 it becomes irrelevant. But that's a separate point. It's the similar point. I don't want to develop it because it's a similar point like the one I made on conviction about Section 35. All it means here is just Section 35(3)(o), which deals only with appeals and or review. Yes. Yes. But here's the bigger point, my Lord. In this case, it's common cause that Mr. Zuma was then admitted to remission by the President of South Africa. That remission is common cause as well, and the SCA found this, that the portion that he had served was 3 months, right? And we argued, at least I argued, unsuccessfully, thank God, that the sentence actually had been served, but that was rejected. The court said, no, that sentence, he has only served the sentence up to the time when he was unlawfully paroled. You'll find that, and I think the implications of that are now coming home, because that court said at page 24 of the paper, paragraph 43, we quote what the SCA said, which is binding.
Page 24.
24 of the papers, 43, paragraph 43, is the notice of appeal, madam.
Notice of appeal.
Yes.
This is what the Constitutional Act, the SCA said unanimously. The effect of setting aside the declarator is that once the order in this appeal is handed down, right, which was about August, Mr. Zuma's position, I'm going to say this one slowly, is as it was prior to his release on medical parole, will be reinstated. What does that mean? Once we pronounce this, as at the point at which he was unlawfully paroled, his position is there. That is at 2 to 3 months. That's what the SCA says. They say, in other words, Mr. Zuma in law has not finished serving his sentence. He must return to Escort Correctional Center to do so. Okay, so far so good. So we know how much he has served at that point is 2 to 3 months. What then happened is that as he reported, as ordered by the court, at Correctional Services at Escort, he then was given remission of sentence. And that means it's a simple, the ultimate sentence that he had was the 3 months. Now, remission, my lord, it works like this. And this is where my little friends confuse these terms. Remember, it comes from section 84.2J. And that section of the Constitution. It comes from the so-called, it's the remnants of our colonial past, what used to be called the prerogative. So the reason why this is only left to the president and not even to a minister or some correctional services people is because, as it has been said, it's like a favor, it's just amnesty. It actually undermines the court. I think that's what people say.
Yes, well,
yeah.
But the question, Mr. Mpofu, what is the legal effect of remission
I'm coming
on the
to
sentence?
Yes,
that's a question.
That's really what I'm addressing, my lord. But I have to start by situating it where it comes from.
Right.
Okay. It says at section 84.2J, the president has the powers entrusted by the Constitution and legislation, including whatever, and as the head of the executive, the president is responsible for, in J, pardoning or reprieving offenders and remitting any fines or penalties or forfeiture. That means pardoning and remission of sentence. Now, the mistake my learned friends make, they say their defense, but Mr. Zuma was not pardoned. We agree. Mr. Zuma was not pardoned. The difference between a pardon and a remission is very simple. A pardon is where you forgive the conviction and the sentence. That's a pardon. It's called a pardon. Remission is where you only forgive the sentence. That's all. It's not rocket science. And so what we are saying is that this point, if he was pardoned, then we would be saying, my lords, scrap both the conviction and the sentence, but this is just about sentence. So the effect of remission has been clearly described. In fact, the synonym for remission is to cancel. Cancel, and in the thesaurus, it even says to set aside. That's the best way.
Sorry, Mr. Mpofu.
I'm sorry, yes.
If I understand you well, you are saying the effect of remission is basically to extinguish the remainder of that particular sentence.
Yes.
And as a result, that would not amount or qualify as the 12 months as per section 47.
Absolutely. Thank you, Professor. So the ultimate sentence, remember we said in section 47 searches for something called the ultimate sentence. That's why when it says you must wait for the appeals to be adjusted, whatever, it's all about what would be the ultimate sentence. So in this case, the ultimate sentence, as a result of a remission, not as a result of an appeal or a review or anything, is 3 months. And here, I'll hand this up. This is what it says in the thesaurus. Remission is a noun. It means cancellation, setting aside, suspension, revocation. And that's the first example. But the law dictionary, the Oxford Law Dictionary, says remission is cancellation of part of a prison sentence. So all of them, Professor, you're quite right, talk about cancellation, extinguishing, but the one I like is setting aside. In other words, once the sentence is set aside, whether it's set aside as a result of an appeal or a review or a remission, it is set aside. Now, the point is this. We're dealing with a penal statute. A penal statute has to be interpreted restrictively. We're not only dealing with a penal statute, we're dealing with a penal statute that takes away political rights from people. That's even worse. It means that there must be even further caution. So how can you say when the statute, or rather the section, is clearly directed at the ultimate sentence, then we say no, forget about that. Forget about the appeal, forget about the review, forget about the remission. I call their defense finish and clap. They just say, look, he was sentenced to 12, convicted, sentenced to 12 months, finish and clap. Forget about the rest of the section 47. Don't read it. Stop at where it says 12 months. You can't do that. The whole point of the drafters, including those words, was not to play. It was to make sure that what it said in the governing section, every citizen has a right to vote and so on, except. So the exception has to be interpreted in that manner. So, what does that all mean? What it means is that if the effect of the remission, and your lordships will find in the cases, the bundle, our bundle that we just ended up, we'll find two cases that we refer to. Smith and Mushiho. Yes. Let's start with Smith to page 58. Page 58 of our bundle. And I won't read the long passages because of time. This is what Smith says in paragraph 34.
Yeah, you have to wrap up, Mr. Mpofu. You have gone way beyond your allocated time. But yeah, okay, that's fine.
It should be noted at this stage that it becomes very important.
That's page 58, né?
Paragraph 34.
34.
Yes.
It should be noted at this stage that it becomes very important for the applicant to determine from which sentence the 24 months remission should be deducted, extinguished, cancelled, whatever. And then it says at paragraph 39, the following page, what becomes one is the effective term of sentence, in that case we were talking about concurrent sentences, which must be served. Remission and parole will be considered in relation to the length of a term of imprisonment. In other words, both cases, both Mushiho and Smith, were concerned with the following question. From which, what is X? If you say remission is 1, and and if you have X minus C, let's say, or R, X minus R, which is the remission, what is what then remains? So that you can then apply the parole. I'm paraphrasing So this is what happens in real life. If the president says, I'm giving a remission of, let's say, 2 years, if I have a 20-year sentence, that sentence becomes an 18-year sentence. But if I've already served, I'm only left with 2 years, let's say, then I get released. But both of us, it doesn't matter. The fact that I go home and you don't go home doesn't really matter. It's simply because my sentence was towards the end. But the remission is applied to both of us exactly in the same way. And that's why the court said that.
But when a remission kicks in, does it affect what is recorded in the so-called SAP 69? Because that is where the previous conviction are recorded in the SAP 69. If somebody was sentenced to 15 years imprisonment, and then along the way he get paroled,
It's still a 15 years.
what is going to be reflected in the SAP 69?
My Lord, the answer is I don't know. But that's not the point we're making. The point that question can also be asked about what happens if your sentence was 20 years and then you appealed, then it was reduced to 10.
Well, if it's reduced on appeal, then the SAP 69 will be changed.
Exactly. But that's the point we're making. If it is reduced, if your sentence, your ultimate sentence, is reduced to 3 months for whatever reason, remember that's where we started. We said the purpose of the section was to look at the ultimate sentence. So whether that ultimate sentence happens, okay, let's come to the other example you made, Malek. If it's set aside by way of review, if it's set aside by way of review, the SAP 69 will also show you that it's zero. It's the same effect, Malek. That's what we're saying. That's why they say I think it's the case of if the Lordship just bears with me, I don't know if I think it's yes, right. Paragraph 66 of Smith, it's on page 67 of our bundle, answers that question squarely.
Yes.
Okay, it says the total sentence, remember, here of the applicant was to serve was 18 years. Put there 15 months. Right? If the 24-month remission was deducted from this sentence, it would leave a sentence of 16 years imprisonment. A sentence, not anything else. So the sentence that would remain after you've taken the remission would be a sentence of 16 years. So let's bring it home. That sentence would then read like this. The total sentence with the applicant was to serve was 15 months. If the 12 months remission was deducted from this sentence, it would leave a sentence of 3 months.
So, Mr. Mpofu, under normal circumstances,
Yes, ma'am.
it's a court of appeal or a court sitting in review proceedings that may interfere with the sentence that has been imposed, right? That's under normal circumstances.
For a conviction.
Yeah. No, I'm not dealing with the conviction. I'm dealing with the sentence, which is your case, right? You're not disturbed by the conviction. You're not impugning the conviction here. We're here because the issue is whether the ultimate sentence remains that imposed by the court or whether the president reduced it, right? Now, essentially, you are saying there was no appeal here. There was no review of the sentence imposed by the court, right? That's common cause.
Yeah.
The president then exercising his powers in terms of section 84(1)J remitted the sentence. And the effect of that is that he interfered in the same way a court of appeal would. He interfered with the sentence that the Concord imposed, and as a result, the sentence was no longer 15 months, it was 3 months. And that is why when Mr. Zuma reported to the prison, he effectively walked. Because the remainder of the sentence had been interfered with. It was no longer 15 months.
Absolutely.
It was 3 months, which he had already served.
Yes.
And that's why he was allowed to go home.
I couldn't put it better, Malene, than that. And the issue of it was extinguished by a lawful process,
Yeah.
which is the reduction, cancellation, setting aside, whatever
Through
you
a
call it,
presidential remission.
of a presidential remission, yes. Which is different. That's
So,
why,
sorry, Mr. Mpofu, it's not the entire sentence which was extinguished, it's the remainder of the sentence.
yes, it extinguishes the remainder. No, that's what I just said. The Oxford Law Dictionary says the remission is cancellation of a part of the
yes.
sentence. Yeah. No, we're on the same page. But that part is that's what Justice Madiba is saying. That part is the 12-month remainder, the part of the sentence. That's all we're saying. We're not saying he goes back to zero. No, the 3 months stays until the point, just as it would happen if it was an appeal. I think Justice Madiba has put it. That at that point you can't say if you've been sitting for 6 months.
I think that you have covered all the points, Mr.
Yes.
Mpofu. Your points were bias, which are various, conviction and sentence.
No, the bias.
Oh yeah, sorry. So
Lady,
your colleague is still going to address us on bias.
yes.
Yes.
My Lord, let me round it off like this. We are dealing with a very serious matter
Yes.
of wanting to disenfranchise possibly millions of people so that they don't have the choice of